The Illinois Supreme Court considering whether to knock down a state law that prohibits open carry in the state. Good morning, it's Illinois in Focus Daily. I'm Greg Bishop, still on the road, but definitely able to watch what's happening to keep you guys plugged in. So the Illinois Supreme Court hears all kinds of cases that go through state courts. Yesterday they heard a case, Illinois versus Tyshawn Thompson. Now, what happened here was Tyshawn Thompson was arrested in 2020 for having a firearm in a vehicle without proper permit. Those of you who are firearms owners, you know that your firearm needs to be in a latched container if you don't have a concealed carry license. If you have a concealed carry license, it's a different story. But ultimately, Tyshawn was found with a firearm, not in a proper holding, and he didn't have the proper licensing, even though he had a firearm owner identification card. He's sentenced to 30 months. So, case goes all the way through the district courts, the appeals court, got up to the Illinois Supreme Court, and they had that hearing yesterday. Here is Thompson's defender, the public defender, Eric Castaneda from the Office of the State Public Defender, laying out the case here.
Here, Mr. Thompson was convicted under a statute that completely prohibits the public open carry of a firearm in Illinois, and that punishes the failure to undergo a double licensing regime under the CCL Act. Neither of these parts of the statute can survive the Bruin test, and Your Honor should find it unconstitutional and reverse Mr. Thompson's conviction for aggravated unlawful possession of a weapon.
Castaneda further develops his arguments as to why the state statute prohibiting open carry needs to be tossed.
We think that concealed carry and open carry are two categorically different conducts, one which is protected under the Second Amendment and the other which is not. So the government can regulate concealed carry, as it pleases, but the same doesn't apply for open carry.
He also provided the Illinois Supreme Court justices some case law that highlights how important it is to distinguish between open carry and concealed carry.
The Alabama Supreme Court in 1840, in State v. Reed, stated that the legislature cannot inhibit the citizens from bearing arms openly because the Constitution authorizes him to bear them for purposes of defending himself and the state, and it is only when carried openly that they can be efficiently used for defense. And so that's a dead ringer that they understood that the Second Amendment only protected open carry.
Now there's a question from one of the justices, Chief Justice Mary Ann Teese, which I think really gets to the crux of some of the argument here.
The original charges were about a drive-by shooting. And there, on the issues about the use of the weapon, the jury was hung, and eventually those charges were dismissed, and all that was left was the charge related to the gun in the glove compartment, right?
Correct. And that's what I argued below, Your Honors, and I thought that's what the fact should have been confined to. But that was simply not the case. That's not what the court found. That's not what the state argued. The state argued that at some point he possessed that weapon in the vehicle, and Ballark tells us that possessing a handgun in a vehicle, I believe that's a First District case, is open carrying. So we do have open carrying here. And it's really not a factual distinction that Your Honors have to engage in. All Your Honors really have to engage in is whether he was convicted under a statute that prohibits open carry. And that's what Aguilar tells us. That's what Your Honors held in Aguilar, that as long as you were convicted under the statute, then you have a right to challenge the constitutionality of that statute.
So again, that was Eric Castaneda. He is with the state's public defender's office defending Thompson in this case. Now, defending the law is the Assistant Attorney General Garson Fisher. He laid out that, what exactly the state's position is on this case.
The court said in no uncertain terms that shall issue licensing regimes, including explicitly Illinois', are constitutional.
Fisher also spelled out what he believes is the makeup of the Second Amendment and what exactly is covered by the Second Amendment.
The defendant's conduct here, the unlicensed carriage of firearms, when the licensed carriage of a firearm is readily available to all ordinary law-abiding citizens, is not covered by the plain text of the Second Amendment.
Now, one of the arguments was Illinois has a dual licensing scheme, a two licensing scheme. If you want to be able to buy and possess firearms and ammunition, you need to get a firearm owner identification card. If you want to carry it out in public, concealed, you have to get a concealed carry license. Some of the things that Castaneda was saying, Illinois has this two licensing scheme here where it really is hindering individuals' ability to exercise their Second Amendment rights, even to open carry, because, well, they can't defend themselves without getting permit by the state or facing, criminal penalties. But you've got the state's Assistant Attorney General, Garshawn Fisher, spelling out what he says is, it's totally legit and constitutional to have this scheme.
And the mere fact that a FOID card is a prerequisite to subsequently acquiring a concealed carry permit doesn't make Illinois' system an infringement on the right to carry firearms. And the court was explicit that things like fees and processing time, and even explicitly firearm safety training, which is one of the aspects of the CCL Act that is different than the FOID Card Act, are not infringements on the Second Amendment right to carry firearms. So the mere fact that there is a second licensing requirement, so to speak, a prerequisite license to get a CCL, doesn't make Illinois' CCL requirement an infringement on the right to bear arms.
Garshawn also gives some recent case law that he says builds their case to defend the prohibition of open carry in the state of Illinois.
The Fourth Circuit upheld a dual licensing regime in Maryland. The U.S. Supreme Court earlier this week denied certiorari in that case. So I don't think there's anything about the prerequisite that you have a FOID card that makes Illinois' scheme unconstitutional.
Now, as these cases go, you have the appellants, the appellees, and then the appellants give their rebuttal. Here's Castaneda with his rebuttal.
In Bruin, that statute did not completely ban people from possessing guns in public. It simply required them to, show a heightened sense of self-defense, which was found unconstitutional. But it wasn't a complete ban on carrying firearms, and yet the court found that that was an infringement. In Rahimi, the court quickly went past the first step to the second step to find that the Second Amendment was implicated. And for all these reasons, Your Honors, we ask that you find that the AUPW subsections A1 and subsections 3A5 are facially unconstitutional, and that you reverse Mr. Thompson's conviction for aggravated unlawful possession of a weapon.
We'll be watching for whenever the Illinois Supreme Court makes a ruling on this case, but clearly it's going to be an interesting one, as it could be a few months. But of course, you can go watch the entirety of that hearing. You can find the Illinois Supreme Court's streams. Just go to their website, and you'll be able to enjoy all 45 minutes of the debate back and forth on that issue. It is Illinois in Focus Daily. Like, subscribe, hit that notification bell, and join us each and every weekday morning. And get the headlines in your inbox at thecentersquare.com.